Hello, this is Matt on the Moon Lambo channel. You know what's on your screen right now? Well, you do if you're looking. This is CoinMarketCap.com. Now, I'm not a big fan of CoinMarketCap.com for a number of reasons that I've shared over the years, let's say. So why do I have them pull up on my screen? Well, I just wanted to let you know that this is the website that the SEC is using to find evidence against Library in the SEC versus Library case regarding their LBC Library Credit Token. Kid you not. So Attorney John Deaton's got some comments on that. And also, excuse me, folks, the SEC is basically trying to trick the judge as far as I'm concerned because, Attorney Deaton, he points out why the SEC's claims surrounding specifically attorney-client privilege are just nonsense. They're complete and utter nonsense, and he shared some thoughts on that. So basically got a few updates on a few different topics, including the topic of SEC ethics, or lack thereof, should I say. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so Attorney John Deaton tweeted out the following this morning. He said, "How do we know the SEC's claim of attorney-client privilege for every single email, comment, edit, and draft related to the speech is nonsense?" Well, the SEC would have argued attorney-client privilege before the DPP, deliberative process privilege. There's no exception with the attorney-client privilege in this case. DPP has a need-based exception. And so part of what he's talking about here, obviously, is that attorney-client privilege, you'll see as I go through, because he ends up expanding upon this, that claim is so powerful that if true, that's where you'd start. There's no need to make a claim of privilege for specific documents if there's an attorney-client privilege, right? So that's part of what he's getting at here. So that's why the assertion that they're making here, as Attorney Deaton said, every single email, comment, edit, and draft related to the speech, the idea that it's attorney-client privilege it is nonsense. Now, my fellow XRP YouTuber Mickle XRP wrote, "John, can you break this down a little bit more?" And he did actually. He created a short thread here, which is on your screen, which is what I wanted to run through. So it's like, how do we know that the SEC is making a nonsense claim that even they don't believe? Because I don't think they believe that the crap that's spewing out of their mouths. They're just trying to trick the judge. If they can actually convince the judge that what is not true is actually true, then hey, see. But look, the odds of this going through, it's so low. That's why I've said before, like, to me, this seems like a Hail Mary attempt on the SEC's part. But here's what Attorney Deaton had to say. "A judge can find documents covered by the deliberative process privilege, but if the documents are exculpatory or very relevant to an issue, i.e. fair notice, and Ripple has no other way of obtaining the evidence, the judge can pierce through the privilege." And so again, just to be clear, they started with DPP, deliberative process privilege. They're saying, hey, these internal documents, these are privileged, Ripple shouldn't have them, shouldn't be a part of the case. But if the judge reviews those documents and then sees that, hey, there's something that's actually highly relevant in here, even if privilege would normally apply, the judge can say, nope, this is relevant, it's part of the case. That's effectively what he's saying there. And then Attorney Deaton continues. "Hence, a document can be covered by DPP, but still be ordered to be produced to Ripple. It's not an absolute privilege. An example is the meeting the SEC had with SBI, Ripple's largest shareholder. The judge said it was covered by the DPP, but Ripple could ask SBI what was said. So she didn't pierce the privilege and order the documents of that meeting to be produced." But here's the money part right here, as far as explaining why they did this completely bass-ackwards, which is how you know, like, they don't believe the crap they're arguing. Attorney Deaton says, "The attorney-client privilege in this case has no exception like need. It is a bulletproof privilege. So, if you were the SEC, you would have argued the attorney-client privilege before arguing the weaker DPP privilege." So pretty open and shut, right? Pretty damn clear here. If attorney-client privilege, if it's a real thing, you start there because Everything's bulletproof. The judge, even if the judge could see something that pertains to something that is genuine attorney-client privilege, even if it's exculpatory, the judge can't say, "Oh, look at this. This must be considered within the case." The judge cannot do that. But with DPP, which is what the SEC started with, you can. But you see, DPP was closer to being grounded in reality than attorney-client privilege. That's why they started there, right? These freaking asshats, as if the judge can't see through. I mean, I'd be shocked if the judge fell for this, but they're literally, from my perspective, trying to trick the judge into falling for something which clearly is not grounded in reality. She's not a stupid lady, though. She ain't gonna fall for it. That's my bet. Now take a look at this. This is from Eleanor Turt, who is a journalist at Fox Business Network, and she shared a screen grab having to do with ethics and the SEC. And so she wrote the following: a screenshot taken from the SEC's post-employment reference guide, an ethics reminder. And then she wrote, it would be interesting to know whether Clayton and Hinman consulted the ethics office before going into their respective crypto-related post-careers. Reasonable question. I'm going to guess the answer is no. I'm going to guess that the answer is a pretty strong no on that. And so here's what Attorney Deaton had to say about this, because he retweeted that and he wrote, Hinman ignored direct orders from the ethics office not to meet with Simpson Thatcher. He met 3 more times after being told he was barred by statute. Do we really think he had his speech or his post-employment screened for conflicts? And Clayton knew of conflict and signed off. Yeah, which makes it that much more repulsive. Clayton was totally fine with all the Hinman stuff, right? In fact, he contributed to the speech. He provided input. We know that. That's not speculation. He did. So no, I don't think that they're exactly concerned about ethics, or honestly, even the optics of following the ethics considerations that even the SEC, their ethics office, says must be followed. I don't think they even care about a bad look. These are just such arrogant people. And then there was this, and I find this comical. This is why I had CoinMarketCap open at the beginning of the video. There was a tweet yesterday from Library, and they wrote, all of the evidence the SEC has submitted regarding historical exchange of LBC is literally just screenshots of CoinMarketCap. And then they have a little facepalm emojis, which I gotta admit, I do find kind of comical. And so Attorney Deaton retweeted that and wrote the following. Everyone should be alarmed at the lazy approach by the SEC in the Library case. Also, the SEC isn't relying on a single expert witness. Why is that so alarming? Does that mean the SEC believes it doesn't need one because they are confident the judge will go along with the government? No, that's a good question, Attorney Deaton. Why wouldn't they have an expert witness? They did in Telegram. The SEC has one, more than one, in the Ripple case. Why do they feel they don't need that here? What is going on with the judge? And so I'm familiar with the SEC versus Library case, obviously, not to the same degree I am with the Ripple case. I don't know as much about the judge as a result of that. So it does make me kind of wonder, is this judge historically one that just goes along with what the government says? Because, hey, the government, they probably know what they are. And it's not only that. A lot of times I believe that sometimes judges have higher aspirations, or like what's going to happen after they're done being a judge. And you do kind of wonder, like, what are the implications of that? And so, look, I'm not saying that there's some sort of rampant problem regarding that, so please don't misunderstand me. I do think that, generally speaking, justice is done. But judges are humans too, right? So there's always some sort of question mark to some degree, which is why I'm actually really thankful we've ended up with Judge Netburn and Judge Torres in the Ripple case. But here, it's kind of an additional question mark for me here. Why would they not need to have an expert witness? It is kind of concerning, right? I mean, the SEC, you'd think they just want to bring the hammer down to, like some sort of crazy degree, like they certainly are in the Ripple case. Yet we don't see that here. I don't know. We can speculate. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.